We are here in the case of Victoria Evans versus Metropolitan Hospital, case number 23-03520NH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court today on Defendant Metro Hospital's motion to compel depositions and discovery of electronically stored information. At this time, I'd invite counsel to place your appearances on the record. We can begin with plaintiff.
Good morning, Your Honor. Leanne Pregazer on behalf of the plaintiff.
Thank you.
Good morning, Your Honor. Thomas Nafziger on behalf of the defendants.
Thank you, Mr. Nafziger. Mr. Nafziger, this is your motion. The response indicates the deps have already been taken. Is that true from your perspective?
Yes, that's correct. We do not need the court's intervention for that part.
So that brings us solely down to the request for electronically stored information.
Correct.
All right. Why don't you elaborate on that? I did review the request itself, which does encompass 12 years. However, it appears the child's about 12 years old. Is that right?
Yes, that's correct.
And do you have any indications from the deposition of the plaintiff's rep that those photos or electronically stored information relevant to the case exist?
Yes, there were references to it in the deposition, and Ms. Pregazer, I apologize if I'm not pronouncing that correct. She had indicated in the deposition that she would send the photographs to our office afterwards, but instead they continue to object to them. They have also listed them on their exhibit list and in their initial disclosures, but continue their refusal to produce them.
And when you say photographs, are you referring to, when I think of photographs, I of course think of the old school boxes of photographs like we used to keep. Are these electronically stored somewhere?
It's our understanding that all of them are electronically stored. We know at least one of them was included in the original complaint, which the court has stricken, but plaintiff continues to use. They keep using the parts that the court has stricken. It was attached to this motion as an exhibit as opposed to the amended complaint.
Yes, I did see the photograph of the child that was attached to that original complaint there. And your indication is, and do you have an idea that were these photos posted electronically on social media, or are they simply stored in devices as far as you know?
We know from the deposition that at least some photographs have been posted to plaintiff's Facebook page. We also believe that there are some that were stored on her personal phone. During the deposition, she indicated that they were produced to plaintiff's counsel, but she was instructed not to bring them to the deposition.
Okay. And then I guess, and you haven't subpoenaed the Facebook account to obtain at least what Facebook has for records. And obviously you have the ability to view the public portions. Have those been taken down from the Facebook account as of now?
My understanding is her profile is private. And contrary to what plaintiffs assert in their response, we are not seeking authorization for the entire Facebook account. We've asked for them to sort through it and produce the photographs and videos and messages relevant to this case. But to be clear, we are not asking for access to the entire account at this time.
And when you say messages relevant to the case, you would mean captions or postings on Facebook that would be related to those photos, or just anything related to the child?
It would be anything related to the child or the mother's care at issue here. Including any private messages or communications, anything in the standard discovery request that's at issue here.
Okay. And when you say in her possession, that would mean that she has access to either on a stored old Facebook profile or a private Facebook profile, or in her, for example, her texts that she may have stored on an electronic device.
That's correct, or any that have been transferred over to a computer or some kind of external storage of any kind.
And do you have any indication, I understand she did testify that she did keep a Facebook profile, that such texts for example, a text message or an instant message, that there is something there related to the child, the medical care, or this case?
That we are unsure of. We don't have access to her profile, so we're not. It's up to plaintiff to tell us what
If
relevant
there's
messages.
anything in there, or if nothing exists, i.e. she didn't communicate via text with anyone regarding the child's medical status, current status, or the nature of the case, other than perhaps anything that would be privileged. And you haven't received a privilege log in the matter.
No, I don't believe so.
All right. Ms. Pergazzer, I'll let you respond.
Yes, Your Honor. So when it comes to the photographs, I don't particularly have an objection to producing photographs of the minor child. It's the fact that it's overly broad and unduly burdensome to go back 12 years to try to find anything related to the child's care, anything related to mom's care, as defense counsel is requesting.
Well, the child's 12 years old. Why is that so overly broad?
Particularly because the child has been treating with multiple treaters.
Well, I assume that's all been, obtained through medical records. I don't think anything there, but certainly mom's recollection or anything, that she entered electronically regarding the care of the child. Um, uh, I'm failing to see why that might not be relevant.
Well, any concerns that mom has regarding plaintiff minor's care is also contained in the medical records. Defendants have had the ability to depose mom as well as the other family members that are closest to the child. They have access to plaintiff minor's medical records. They have a QPO in place, so they have access to plaintiff minor's treating physicians, unfettered access without plaintiff intervening in any sort of way. And they've had 2 independent medical examinations completed of plaintiff minor. That is the relevant evidence in this case that shows the nature and extent of the plaintiff minor's injuries. Any messages back and forth from mom regarding plaintiff minor's care, especially trying to go back 12 years and find that information, is burdensome to mom.
Well,
And
mom's asking for $25 million per my complaint here. I don't understand how that wouldn't be related or certainly not an unreasonable request given the amount of damages claimed. But I guess that's my position there, is it's not too much to ask. Now, if mom comes back and says, you know what, I don't have my phone from 12 years ago or my messages, and she wants to send a response that says as much and certifies it as a discovery response, then we'll move from there. But I don't see any basis for mom. And, frankly, I've seen enough of these cases go that, of course, a staple of a plaintiff's case is going to be a day in the life video. Well, of course, that requires, access, to all those records, as Mr. Nassiger and co-counsel point out in their brief. You have to have access to the records to create that video. It's only reasonable that they have access to records that would perhaps rebut or counteract the claims that might be made in a day in the life video. So I don't think it's overly broad. How long do you think it's going to take to put that together? I mean, I'm thinking just out loud here, a 30-day response deadline. Is that reasonable?
yes, Your Honor.
All right. Then what I am going to do is I'm going to deny the motion in regard to the depositions, because that is moot at this point, the depositions having been taken. However, I will grant the motion in part regarding the request for production, and that will be that any photographs, social media references in text or electronic messages that are non-privileged be produced, and that any privileged messages be identified on a privilege log supplied to defendant's counsel. And that would, of course, include if there are stored photographs. I know that I take 1 million photographs of my kids. I don't personally post them on social media, but I know people don't always post every photograph they have. You know, if there are a bunch of photographs, they can be produced. Of course, those ideally would be produced in their native format. However, realistically here, you know, we're talking about 12 years of life of a child. There may be a lot of photographs, but any of those that are certainly in mom's possession do need to be produced. And I think that's in the name of fairness here. I don't think it's disproportionate in this case because, as I said, the damages claimed are significant, and thus proportionality, you know, is really, you know, if this was a $10,000 case, it'd be a different story, but this isn't that. This is a multi-million-dollar case, thus far-reaching discovery into the 12 years of this child's life is warranted, at least in the court's estimation. So, and I will direct that to be produced within 30 days, that is by August of the 11th, 2025. Can you send me an order granting that and just referencing the record, Mr. Nasiker?
Yes, Judge.
Very good. Thank you both. I appreciate your time, and it was thoroughly briefed. I appreciate it.
Your Honor, one more thing while we're
Oh,
on the
yep.
record. I just wanted to reiterate the fact that plaintiff is continuing to use materials that this court has stricken from the record. And can we just get an instruction that they do not use the stricken complaint anymore and publicly file stricken material?
Your Honor, that was inadvertent. I'll assure that our office does not file that again and uses the amended complaint.
Very well. I will, you know, certainly that is reasonable, and any further use of it would be grounds for an order to show cause.
And Judge, I apologize. One more thing. Am I to understand that you are not going to rule on our request for expenses for bringing this motion?
Yeah, thank you. Yes, that's correct. You know, in a you know, case where I'm enforcing a discovery order, it would be different. It would be normal for me to enforce, you know, to grant attorney fees. However, I do have the discretion to grant those in a request to produce items. However, in this case, because of the well-founded objection, you know, to the original breadth of the request, I don't think they're warranted.
Understood. Thank you, Judge.
Thank you, Your Honor. Have a good weekend.
Thank you. You as well.
We are here in the case of Frankenmuth Insurance Company versus Ryan Hansen and al.
And this matter comes before the court today on cross motions for summary disposition on Frankenmuth Mutual Insurance Company's declaratory judgment action against both Ryan and Sarah Hansen, as well as the Solomon Building Group and Christopher Strubusher, a matter that was tried before the court some time ago. So at this juncture, I would invite counsel to place your appearances on the record. Ms. Pinch, I guess you're the plaintiff in this matter, so you can go first.
Thank you, Your Honor. Teresa Pinch, P56150, on behalf of the plaintiff, Frankenmuth Insurance Company.
Thank you very much.
And Your Honor, Fred Boncher, on behalf of Ryan and Sarah Hansen, the two of the defendants in this declaratory judgment action.
All right, very good. And just to clarify, obviously, you're not here on behalf of Solomon Building Group and Mr. Strubacher. They stand on their own. They had separate counsel during the trial, but you're not here for them today.
That's correct, Your Honor.
All right, very good. All right, I think the initial motion was by Frankenmuth Insurance Company. So, Ms. Pinch, I will let you lead us off.
Thank you, Your Honor. Before I get to that, there was also a motion pending, our motion to exceed page limits. Does the court want me to address that, or is that now moot, given that we're here?
That is moot, and I will grant the motion. I routinely grant those to exceed page limits, though I will admit with some reticence to do so. However, I always say I'd rather have it well briefed than someone cut themselves short because of a page limit. So I'll grant that motion, and you can proceed, Ms. Pinch.
Thank you, Your Honor. With regard to the motion for summary disposition, it's important to note at the outset that no one has responded or replied on behalf of Solomon Brothers or Strubusher. And for ease of reference, I'm going to refer to Solomon collectively as both Solomon and Strubusher, rather than trying to say that repeatedly.
Yep, no, that'll be fine.
Thank you. The original complaint brought by the Hansens against Solomon and Strubusher alleged 4 causes of action. four counts, one for breach of contract, one for fraud and misrepresentation, one for promissory estoppel / unjust enrichment, and one for breach of warranty. Back in July of 24, almost a year ago, we had a hearing on a motion for us to intervene, for Frankenmuth to intervene for the sole purposes of assisting in crafting the verdict form and the jury instructions in order to assist the jury in allocating its verdict if it were to find in favor of the Hansons, because some of those claims may be covered and some of them absolutely are not covered under the terms of the policy. Counsel for the Hansons objected and the court denied that motion. In retrospect, had that motion been granted or had the Hansons agreed, we wouldn't be here right now. It would be very easy to discern what parts were within coverage and what parts were not.
Well, I
However,
have to pause you there because I do recall the jury verdict and, we've had, of course, numerous post-trial motions involving that, but the jury did come back with a, somewhat, confusing verdict in that they awarded a very specific dollar amount and they awarded it essentially on all counts of the complaint. Perhaps signaling in some respects that they weren't able to make head or tail of the precise, source of the damages there. They were obviously very specific about the amount of the damages, but they were unable to attribute them to, any of the specific, or perhaps even more broadly, they attribute it to a combination of all the things alleged in the complaint. Is that a fair interpretation of a jury verdict?
it's a fair interpretation of what the verdict itself stated, but our position is that, you may recall, Your Honor, I sat through that entire trial. The jury verdict was rendered late in the day on a Friday afternoon. They aren't here for us to ask, why did you answer yes to all of these? As I recall, one of the jury instructions was, if you find yes on breach of contract, do not address promissory estoppel and unjust enrichment. Clearly, the
Which
jury
they simply
disregarded that.
disregarded and went forward and
They
answered
just
it
checked
anyway.
everything.
Right,
And that's,
right.
and perhaps had they been given a verdict form that broke it down, they would have done so, but they didn't. They didn't have the opportunity. So now we have to deal with what we have before us, and that is a jury verdict that found in favor of plaintiff on all four counts, some of which may have been covered and some of which may not be covered. And we have this lump sum of just under $400,000 to try and figure out what coverage, if any, Frankenmuth is responsible for.
Right. Well, and I think one of your first arguments that you raise is the near impossibility of doing that, given the nature of the verdict and the way it was rendered, that it makes it impossible to allocate it. Now, I guess if I play Mr. Boncher's argument here that, well, Michigan doesn't require allocation, isn't the flip side also true that it's impossible, because it's impossible to allocate it, that I should just allocate it all to Frankenmuth?
No, Your Honor, if you're going to do it that way, I would say it should all allocate to breach of contract, because that's really what this all comes down to. And there is no coverage for breach of contract under a policy. The policy only applies to occurrences, and a breach of contract is not an accident. The definition of an occurrence states explicitly that an occurrence is an accident. If there was no accident, there is no coverage. And the court, just as it cannot say, well, it all fell under breach of contract, or it fell all under breach of warranty, or it should be divided equally between the four causes of action. There's no basis for the court to make that allocation because the jury didn't do that. And while we do have Mr. Boncher's speculation as to how they thought and what they decided, that's his interpretation, and that's not a basis for the determination of Frankenmuth's coverage.
What about, let me back you up on that occurrence, because that kind of brings to the next argument, and that's the direct language of the policy here. And it does define an occurrence. And of course, the very premise of casualty insurance in the first place is, based on, I think you supplied in your brief, a definition of occurrence that is something unexpected or anticipated that occurs and causes the damage. Now, and you mentioned the breach of contract, and of course, if it were a straightforward, there was a written building contract signed by both parties and specifying A, B, C, and D, and some of these cases would be simple. My recollection is there was never reduced to a written contract here, that they proceeded on a series of oral agreements. This thing got built, but somewhat haltingly, and during that build process, there were allegations that there were these lengthy pauses, both sides kind of pointing the finger at each other, but the jury obviously attributing them at the end of the day to the builder in this case. And second, that during those lengthy pauses on top of it, that he failed to secure the site properly, that is by tarping it or, protecting it in a way that would prevent weather damage from occurring, and that the lion's share of the actual damage that occurred and it resulted in, was essential a total tear down and rebuild here, was due to that, water intrusion, due to, and they, even the Strubacher, I think, when he testified, said, well, Judge, it was, or jury members of the jury, was severe weather. The temperatures were extremely low. There was this freeze thaw thing going on, and, that may have been a reason that the work didn't get done, and certainly probably was a reason that the weather protection that they did put up, the tarps and things they put up, failed. And I guess my question is, in terms of occurrence, if I view the occurrence more broadly as, there was a breach of contract occurring, but also a delay, also weather and improper securing of the site, aren't we then into, we're getting into something that no one intended for, but that occurred and then falling under the occurrence definition? The combination.
To answer what I think you're asking there, Your Honor, the term occurrence refers to the actions of the insured. What did the insured do that was an occurrence? And that, by definition of the policy, you're right, we cited case law that says something unanticipated, etc. But the actual policy language says an accident, and then an accident is defined in the case law. I'd ask you to look at the specific claims made by the Hansons in their complaint and simply we can address together whether or not those were accidents and thus occurrences, or whether they were intentional acts on behalf of Solomon. If they were intentional, there is no coverage. The Hansons alleged that Solomon had no concept of proper construction techniques. That's not an accident. If it's true, and the jury apparently found that it was, that's not accidental. Solomon did not follow proper construction techniques. Again, not an accident, hence not an occurrence. Solomon violated numerous building code provisions, and these are plaintiff's allegations in their complaint and as set forth in the trial itself. Again, failure to follow building code provisions is not something one does accidentally. They claim that Solomon engaged in construction practices that resulted in dangerous conditions.
Well, let me just pause you, Ms. Pinch, on the concept of accident, because I get it right. The accidental nature, I guess refers to me to the damages that occur. But of course, in the world of at least my view of liability and insurance in general, you're insuring against negligence at the end of the day, not necessarily, something unanticipated that just occurs out of the blue, but rather something that occurs because of a negligent error. Is it enough to say the failure by Solomon Hansons to follow those, construction techniques, or I guess construction techniques is as good a technique as I can use there, was negligent? That, they did it, but they didn't, they attempted to do something, but they did it negligently. They executed it in a negligent manner, i.e., no one's saying they didn't do anything, or that, but that rather when they put their hand to it, it was done negligently or improperly. Is that possible?
It would be possible had negligence been pled in this case, but it wasn't. Negligence was not a legal theory set forth by plaintiff at any time during the years that this matter was pending, and it was not argued to the jury. So negligence could not have been the basis of its allocation of its verdict.
Well, you
or
say
assessment
right
of
here, I'm
damage.
on page 3 of your motion that says they allege that defendants were negligent in a number of ways, including failure to protect plaintiff's real and personal property from elements including rain or snow, and then you reference Exhibit A, which I think might be the complaint, on there. It looks like there you're conceding that there are claims of negligence.
First, I didn't write that brief. I didn't write any of these briefs.
I
But looking
apologize
at
then
the-
for holding you to someone else's work.
I understand that. And regardless of what another individual wrote, the court and the jury were addressing only the claim set forth in plaintiff's complaint. The jury was not making an assessment of negligence because negligence wasn't before the jury. It had not been pled. It was not a part of anything that led to the verdict. So it's now impossible to say that any portion of the damages was attributable to negligence because that wasn't before them.
I
Had
didn't
it been
instruct the
before
jury
them,
on
we'd be in a
negligence.
different position.
Okay.
And
I didn't
even-
instruct them on that either. I would anticipate then, since that wasn't part of the.
Correct. There was no instruction on negligence given.
Okay. All right. No, okay, I get it. So you're saying no negligence, ergo, this is all a contract claim, essentially at its core. And the breach of contract just simply, even if I breach contract in a negligent matter, it's still a breach of contract. In other words, you can't change the proverbial leopard spots that easily.
Correct. Your Honor, the breach of contract, breach of warranty are essentially both breach of contract claims. Promissory estoppel, unjust enrichment is a quasi-contractual claim, typically only found in the absence of a contract, where here the jury found that there was one. Fraud and misrepresentation is not contractual, but it is certainly intentional. You can't accidentally commit fraud or misrepresentation. There's no question that the policy does not provide coverage to Solomon Brothers for any intentional acts, and that would include the underlying fraud and misrepresentation. So to the extent that any portion of the damages should have been allocated to fraud and misrepresentation, there would be no coverage for it. Similarly, with regard to the business risk exclusion, Hanson's has maintained that the business risk exclusion was inapplicable because they didn't repair the house, they replaced it. The problem with that is that the business risk exclusion language references repairing or replacing. Your work exclusion states, applies to, quote, that particular part of any property that must be restored, repaired, or replaced because your work was incorrectly performed on it. And the your work exclusion is simply informing Solomon that we don't cover your work when your work resulted in property damage that had to be either restored, replaced, or repaired.
Now, I think that Mr. Boncher pointed me to a Michigan Court of Appeals case that found both of those exclusions ambiguous. And if I do find them ambiguous, don't I have to construe them against Frankenmuth?
I would argue they're not ambiguous. The case law, I do not know if those policies had the exact same language in them. I apologize for not having pulled up those policies. But in the absence of proof that the policy language was the same, the conclusions of those Court of Appeals decisions aren't relevant. The court is to interpret the policy that is before it, and the policy before it, the Frankenmuth policy, is very clear with regard to those three categories, restored, repaired, or replaced, because your work was incorrectly performed on it. The entire crux of the Hanson's case is that Solomon Brothers incorrectly performed all of their work on this house from beginning to end, start to finish.
And that would include, obviously, the tarping. I mean, it's easy to say, well, you know, we're talking about a particular part of the house, but, you know, at least in my estimation, construction and the scope of work includes the tarping and protection of materials and the partially constructed structure between work days there. That's part of the work. Is that right?
Yes, that certainly falls as your work under the your work exclusion that allegedly, and as the jury found, led to property damage that had to be restored, repaired, replaced because of Hanson's work.
Okay, and now I think he also pointed me to cases that say, well, your work is where you're actually working on it, not these big gaps or pauses. And there was, I think it was an out of jurisdiction case that both sides referred to. It's this Mid-Continent Casualty versus JHP, which says, well, right, that you not necessarily you have to have your hand to the saw at every moment, but that it does envision this kind of continuous work that I don't think anyone's going to argue happened here. There were certainly gaps between the work, and in fact, one of the disputes at trial that the jury found in favor of was this idea that Mr. Strubacher claimed he was locked out, and of course the Hansons prevailed on their claim that no, he could have gone in there and fixed it. He just didn't work on it for lengthy periods of time. Does that take it out of that work exclusion?
No, Your Honor, I would argue that your work involves the entire project from the first shovel to ground or hammer to nail through the end of the project, whether that results in a successfully built house or a termination of the agreement, whereas Mr. Solomon said he'd been locked out. The Hanson said he wasn't locked out. There's no dispute that at that point, any work ended. Any work during that time period, because in no construction case would you ever have someone on site working every single day, not even continuously, but let alone day after day after day. It doesn't make sense that a your work project would begin and end depending on when there were bodies present. That simply is logically flawed. The your work encompasses the project, and the project is from beginning to termination, whatever the means of termination is, whether that's successful completion or leaving the job or being forced off the job.
Okay, well, and I think you're naturally then leading into the second exclusion you refer to there, which is that business risk exclusion, in that certain risks are assumed in for example, had Mr. Strohbacher underestimated his material cost, and it cost him $100,000 more, and he lost money on the project. Well, certainly that's not an insurance claim, that's a business risk. I think you're saying that delays and at least some of the casualty that occurred here, the damages that occurred to the house, would fall under that business risk exclusion, and that if you take too long, it's not really any different than overbidding for materials. Those are things that businesses normally take on and deal with in the course of business, not insurance claims.
That is correct. And the issue that you really just hit on, Your Honor, is that this is really a dispute between Frankenmuth and Solomon as to whether we owe them any duty to defend or indemnify. They have not responded to that. They have taken no position in this argument. And as I recall, Mr. Strohbacher's testimony was that he really couldn't explain the delays. Yeah, there was some bad weather, but he wasn't able to say, well, we weren't able to get enough wood, or the shingles weren't manufactured anymore. I don't recall him, and I may be wrong, I'd have to read the entire transcript again. I don't recall him stating specific reasons as to why there were delays. Those wouldn't be business risk exclusions if he was just busy doing other jobs, which I believe was part of his testimony, or didn't have men available to do the work. Those would not be compensable. This falls within the business risk exclusion that Mr. Strohbacher does not have coverage for it because it didn't apply to this situation based on his own testimony and the jury's findings. So,
and that is lack of testimony. That is, he didn't cite any, particularized reason. And there were, in reality, of course, if I recall, a variety of reasons. There were disputes about what was to be built in the plans. There were some disputes about redoing the financing. There were a number of disagreements between him and the Hansons, that contributed to, at least in my recollection, the delay in the project here. But all of those you're saying would be encompassed by that business risk exclusion.
yes,
Okay.
and would negate coverage to the Solomons and the Strohbachers. No duty to defend or indemnify for any intentional acts on their part or for anything that falls within the your work exclusion or the business risk exclusion. There's no coverage for intentional acts, which would encompass the breach of contract or quasi-contractual claims.
Yeah, I mean, it's a pretty comprehensive argument in that first there is the impossibility of apportionment given the jury's verdict. And then second, you're saying, well, even if judge, you disregard that and allow, some way to figure out apportionment or in a worst case scenario, you say, well, it should all be apportioned to Frankenmuth, then you're going to have to find that there was an occurrence and that it did not fall under either of those. I believe you cited 3 exceptions: business risk, the work in progress, I guess, for lack of a better term, and then there was one more exclusion, and you're going to have to.
Well, just intentional acts generally,
of course,
which
yeah,
is
broader,
the corollary
right,
to no occurrence, because none of this was accidental.
Sure, had Mr. Obviously, Strubacher decided for unknown reasons to assault Mr. Hansen on the job site at some point. Obviously, you'd be saying, well, that's an intentional act, couldn't have been foreseen, and fortunately not the case that we're dealing with. So, okay, well, I think it's time for me to give Mr. Boncher an opportunity, unless there's anything else that
There is one more
missed.
thing, Your Honor. Our
Yep, go ahead.
motion included a portion that only applies to Solomon and Strubacher, and that was with regard to our claim for restitution for the costs and attorney fees that were expended. If the court finds today that there is no coverage, then we have no duty to defend and indemnify, and we're entitled to that restitution. So I would ask that any order by the court, if you find any portion of this motion to be granted, then that affects restitution from those entities as well, Strubacher and Solomon Brothers.
I see. Yes, of course. If if I rule in your favor, that there was no coverage, then you're asking for a broader ruling, or one that would in effect activate your reservation of rights in the letters that say that we may not have a duty to defend this in the first place, but out of an abundance of caution, we're going to provide that. So, okay, no,
And Your Honor, I will, when we get to Hansen's second summary disposition motion, I will have arguments there as well, but we'll deal with those at that point.
I will give you another opportunity, Ms. Finch, never fear. Assuming, but I should give Mr. Boncher an opportunity to respond to the motion. So, Mr. Boncher, I did review your brief. And how do you get around that pleading issue, Mr. Boncher? She's, of course, arguing here, and I do think it's consistent with your original complaint that it pled those 4 causes of action: breach, fraud, promissory estoppel, unjust enrichment. None of those invoke negligence necessarily, and thereby arguably not coverage. How do you get around that?
Well, Your Honor, we have a specific court rule, MCR 2.118, that allows a party to amend to conform to the evidence. And this is about the most blatant example of that situation, where the parties all treated this as the negligence, and the jury treated it as the negligence, the failure to properly secure the property, and that resulted in weather damage. It wasn't a direct damage by Mr. Strubacher. It was the weather that caused was the ultimate cause of the damages, which resulted from his failure to properly secure the property and come back and check on it from time to time. And so we, in one of our, we had so many pleadings in this, but I know we asked for the opportunity to amend pursuant to MCR 2.118 and MCR 2.116 that says if you can amend to avoid summary disposition, the summary disposition court rule 2116 says that the court has to give you an opportunity to amend to avoid summary disposition. So taking those two together, I think we can amend to conform to the evidence and to avoid any, if the court is
What you're not going to amend in this case. I mean, the case you'd have to amend in is the one that's already been reduced to the judgment, and or at least is in post-trial proceedings. I'm not sure if I've reduced it to judgment yet, but I know that but I mean, isn't it too late to amend in that case?
No, I think you can amend it anytime on that for like, you know, as I recall, that's pretty open-ended. But in any event, when they're making the claim in this case that you didn't ask for that, I think that would be an opportunity to amend the original case.
Well, I'm not sure if it goes back that far. I'll give Ms. Finch an opportunity to respond to that, but that is, at least one of my concerns in going through this, in a sense, rewinding this to the beginning. And I know we did have a number of amended complaints, but I do believe Ms. Finch is accurate in that the claims within the complaint certainly could, and, her, brief, as I pointed out, does acknowledge a claim that could be construed as negligence, because I think you say, well, there was, yeah, let's see here, where did I find that?
You want to wait for one.
Yeah, I'm on page 3 of her brief there, where it says, well, I mean, they characterize it, they allege that defendants were negligent in a number of ways, including the failure to protect real and personal property from elements including rain, snow, and ice. Now, and my recollection here, and I'm going even farther back, is that there is some point where contract law and tort can intersect, and that you can't say, well, this guy breached the contract, but he breached it negligently. The argument at the end of the day still has to be a breach of, from a legal perspective, we're not chained by the old, rules of pleading and law and equity anymore. We still, at the end of the day, have to find the most accurate category to place it under. And it looks like, based on the complaint here, it would be, at this point, breach of contract, or perhaps fraud and misrepresentation. And not to say a breach of contract can involve negligent conduct. Obviously it can, but don't I have to reference back to that original complaint to get there?
No, for a couple of reasons, Your Honor. First of all, under MCR 2.111, you don't have to, you just are to make a statement of the facts on which the police relies in stating the cause of action. And I know there's case law that says just because you put a heading labeling a cause of action as something, that's really irrelevant. What you look at is the facts and look at it as a whole. And that's what, David, that's what the case was all about, the facts of the negligence of failure to properly construe that. And it's notice pleadings. We gave notice of those facts, and it was clear they likewise agreed that it was basically negligence. And so just because we call something breach of contract when the facts really state a claim for a negligence, the heading that we use is not really relevant at all.
Well, I mean, here though, it does, it plays into that, because at the end of the day, then I instruct the jury, and the jury gets instructions on, the causes of action, and they awarded damages here under the causes of action. But none of that included expressly me saying negligence, right?
That's true, but that all these terms are blurred together, like unjust enrichment. He got paid money when he destroyed our house. That's one way they can look at it.
Right. It would be hard to argue that that wasn't negligent conduct on someone's part. But on the other hand, right, so you're saying maybe the breadth under unjust enrichment, or I guess promissory estoppel,
Right,
is the flavor of contract, but unjust enrichment, my recollection is a tort cause of action, right?
that's correct, Your Honor.
Okay. All right. So that's perhaps where it would fit there, is unjust enrichment, and then followed by this negligent contra. And I mean, now unjust enrichment, does that include necessarily, I guess, since it's invoking justice, there must be some sort of intentional conduct. Is that then barred by that exclusion?
No, it doesn't have to be intentional. Unjust, it just has to be, it doesn't have to be illegal. It just has some action that was wrongful that hurt the party claiming that. I briefed this recently on something else, but it's just that unfair that they should pay money when they ended up destroying your existing home. That's what it comes down to, and whether that by some kind of conduct that was detrimental to the party claiming it. And it doesn't have to be illegal. It doesn't have to be a criminal act. It just has to be some kind of wrongful act of some which can include all kinds of negligent acts that ends up resulting in damage to the person and for something you got paid money for and you were unjustly enriched. So I think that answers that question.
Okay.
And I think the
Yeah.
real key thing is what was asked of the jury to find. What was they asked? We asked them for damages for the failure to secure, and they made that decision. That's the only thing we asked for was damages to the existing home and damages to the minimum amount of personal property, and that's what they based all of their decisions on because that's the only thing we asked for, no matter what the complaint originally stated. And I think,
Well, and the jury just, they, for example, there were some replacement kind of housing things, but I think the jury concluded, and I think accurately, that was kind of a wash because these Hansons were so industrious that they actually broke even on their mobile home or whatever that they used for housing in the midst, kind of, probably unintentionally, reducing the amount of their claim, but I think the jury did take that into consideration at least.
and in fact, Your Honor, in my rebuttal argument, I conceded that they broke even, and that therefore we're not really asking that. Even though they had originally asked for that cost of the mobile home that they bought and then sold.
Yeah. Okay. All right. So you're saying that, Judge, don't, slavishly bind yourself to the causes of action in the complaint or even that were presented to the jury at the end of the trial, but rather take a, broader view of this whole situation and see that negligence, and here the specific negligence is the failure to properly protect this project from the elements, is the true gravamen or the crux of what's complained of, and therefore would invoke coverage.
Yes, I think that's well said, Your Honor. And I think the court, with respect to their motion, Exhibit 9 to our response was Michigan law, and that treatise from Michigan Insurance Law and Practice. And we, in our response to their motion for summary disposition, we explain that basically beginning on page 16 of our brief, where they define this standard GL insuring agreements that are determined by the ISO, and we cite in great detail and attach that section of Michigan law, not North Dakota or Texas or Nebraska or anything like that. It talks about Michigan law, and that defines, among other things, what occurrence is, and which the FIC apparently agrees that it's an accident including continuous or repeated exposure to substantially the same general harmful conditions. Well, that was continued and repeated exposure to the elements, and that happened as a result of the failure to secure the property. Which one of the things that even on the breach of contract, it's implied that he would protect the existing, not really stated because we didn't have a written contract, but under an oral contract, he undertook the responsibility to protect that property, and he did it in a negligent way. So that would be constitute, I believe, in itself a breach of contract. So we also in that same treatise, they talk about what's considered intentional or not intentional, and this clearly was not intentional. He didn't intentionally cause a total destruction of their existing home or personal property. I think that's pretty much a given. That same treatise talks about, and specifically, there are three exclusions J5, J6, and K that really, and that Exhibit 9 makes it very clear that none of those apply. There's one of it says performing, and talks about performing operations under J5. Well, that makes it very clear that when you leave if you go overnight while you're wanting something to cool, that's one thing. But when you go on for weeks on end with not even coming back to the job, that's not any. That's not
the timeline there takes it out of that operations exclusion. even if, I mean, I'm just thinking, okay, well, certain projects, and I've seen builds, even in my own neighborhood here, where it appears that, well, they get to a certain point and then they close the thing up with, some sort of temporary covering, or they don't put the windows in or whatever. They close it up for the weather. And they wait until they can proceed with the next stage of construction, and that um, it would seem to me that that would, that there are some delays normally, but part of that operations is also, well, I'm not going to leave the site in a condition where things are going to get worse or damaged, but rather I'm going to adequately protect it. Wouldn't that be included in operations?
No, if that, if you just left it for weeks and weeks at a time, never came back and even checked, and that's not doing, then if they came back every other day and checked everything was fine and they retarped it or something like that, then I guess you could say it was continuous operations. But when they abandon the project and never come back, that's certainly is not ongoing operations.
Yeah, so that abandonment is really the key piece of that there, in that there are these long periods of time where it's not even looked at to see, oh my gosh, the tarping's not good enough. I better get out there and fix that, or have my subcontractor, whoever go out there and fix that thing.
Yes, in fact, I have some very recent experience myself, Your Honor. In December, a big tree fell on my pole barn and smashed up both sides of the roof and two sides, 48-foot long sides of my barn. And because of all, they tarped everything because of, it was during the winter, and they had to wait until all the snow and ice got done. And they come back and check with the tarps once in a while. The tarps were great. I didn't ruin anything in my pole barn, including my golf cart. They checked it, and then they had some good weather this spring where it wasn't raining or anything. They put on my new roof, and 2 days later, another tree fell on the new roof. And so now that's been open because of the recent, they've tarped it again with no leaks coming in at all. Did a good job on tarping it, tarped up the sides that they had already taken off, and no problems with destroying anything, or including
And you're still insurable, Mr. Boncher? I would
well,
have
I'm gonna
given
have
up
to
on
pay
you
a little
long
bit
ago.
more, I think, Your Honor. But yeah, and insurance company, because that was obviously, damage from the elements is clearly an occurrence. My insurance company paid me back by return mail on both of those incidents. And unlike Frankenmuth, that it's looking for things that, excuses that are not consistent with Michigan law, and they try, and even one of the cases that they cited, as I point out in my brief, hurt them. There was a whole different thing. This as far as Exhibit J6 excludes coverage for property damage to that particular part of any property that must be restored, reported, replaced because your work was incorrectly performed on it. That we're not asking for workmanship things. We're asking for, damage because of the elements. And this we
You're
are
gonna have to
asking.
refresh me on some of the trial testimony, because I recall some testimony. There was a question, and I think it went mostly to, did they mitigate the damages there? But when the builder that ultimately undertook the Boverhoffs or whoever
Yeah.
to build the new place and to tear down the old one was looking at it, didn't he come up with numerous shortcomings in the workmanship?
Oh yeah, he did find that, but the problem was that the house was so destroyed by the elements, it was cheaper to start over again and replace it, which is one of the things that they cover, and it had to be I guess it's restored and replaced. It was way more expensive to try and repair it than it was to start over again. So I think that J6 doesn't apply, and page exclusion K not applicable at all. And that's known as, quote, your product exclusion, as the editors of the insurance treatise says, your product is defined as any goods or products other than real property. Well, this is real property we're talking about. It's your products, is defined as goods or products. Well, that doesn't apply at all. So neither J5, J6, or K apply to this. And I think that's pretty clear. And, there was an occurrence, weather event that is typically covered without any questions asked. In fact, we had named as an expert in this case, an insurance adjuster who I happened to talk to yesterday, and she said, "Why don't they just pay that? That's clearly something that's covered." You know, if it were me, I would have paid them by return mail. But they're trying to enter into all these gymnastics to say that it isn't covered at all. Well, it is
And
covered.
you're somewhat hampered here, though, aren't you, by the fact that, I mean, I don't see anyone here for, you know, an attorney for, Solomon and Strubacher pounding the table and invoking coverage to protect him from the liability. I mean, you're forced to do that on behalf of both the Hansons and him, you know, which you ably did at trial. But you're in kind of a strange position here trying to invoke coverage for him. You know, not Hans. I mean, if this was Hanson's policy, it would be different, but this is Strohbacher's policy, so you're you know, that puts you in a different position, right?
Well, yes, but it's kind of interesting because the insurance company provided him with um, uh, uh, counsel for the trial, and then they apparently decided we're not going to provide him counsel with respect to our other insurance
Well, the
company.
deck action, that's kind of you can't be on both sides of it. I don't think they could probably do that, but right. And I know when they did provide him counsel for the trial, of course, as insurance companies usually do, it was under a reservation of rights,
Right.
which is, I suppose, what they're invoking in the motion today.
Yeah, well, let's look at the elephant in the room. You know, he doesn't have any money to speak of. Now we need to take, we're trying to schedule a
Creditors exam of him or some such thing.
Yeah, but from what we can tell, he, other than the money that he got from the sale of the house and invest, you know, for 775,000 or something like that, and invested in a 300 and some $1,000 house, there may be some kind of fraudulent conveyance, but you know, I guess we can't, you know, defend him for if he, you know, they say that, you know, we have somehow have a right if the court rules in their favor on this matter to come after him. I guess they would,
Well, certainly right. I mean, that's the who the judgment's against at the end of the day,
yeah,
is him, right. And I think you're pointing out the realism there is that, you know, oftentimes the only collectible defendant, at least in terms of a cash judgment, would be the insurance company. However, that doesn't though that's a very real concern for you and the Hansons. It's not a legal you know, concern that I can take in an interpretation of the policy. I mean, it's
Yeah.
just straightforward contractual and legal decision as I see it. Let me flip over, since we got on down that road anyways, to your motion or your counter motion for summary disposition, where you
Mhm.
said, well, Judge, of course, I think you should invoke coverage and that the entire loss is covered. Now, as I'm just thinking out loud here, you know, I've come down to the idea, well, the unjust enrichment, and he took the money, ergo, you know, and there was no question he was paid some money up front on this project, and then he negligently performs the work. Is there a needle I can thread or a baby I can split here where I say, well, yeah, but you know, there's an offset to the insurance company, and you know, he should be on the hook for the amount that they paid him in cash, and the insurance company for the damages that he caused when he was out there flailing at this site?
First of all, I think the delay and abandonment also are breaches of contract that started off.
Sure. Yeah. I mean, no doubt that they're going to be collectible against him, but I think you probably agree that the breach of contract's not going to be insured. I mean,
Right.
you insure against casualty, but not against breaching contracts.
Yeah.
Those are different deals.
But if we look at what was, you know, facts are what we had to plead, and the facts were clearly pled in the complaint, talked about the failure to secure the property. And that's what the whole case was basically tried on. And that's what the jury based their conclusions on. And as we indicated in our brief, you know, we can harmonize the jury verdict with what they came up with. They provided for the things that we asked for that were, you know, rebuilding a house. It came out with 71 cents. You know, and that's only a way you can explain why they came out with 71 cents in their total award. And that also that they added provided us with the consequential damages from that, you know, the cost of having to, you know, the fact that their whole house was destroyed, and that.
Sure, and there's some cost to tearing it down, and I think they, you know,
Right.
said, yep, we acknowledge that and included it in there. And then, of course, some damage to personal items, which, you know, probably the most I guess, common type of, if I'm gonna, come across a term, a casualty, well, when I think of it, just like your pole barn, that would be very common if there's some, a problem with the structure, the contents of the structure are damaged and they awarded them, although my recollection is that the lion's share of the award was for the rebuilding, the need to reconstruct this house, essentially from the foundation up because of that, the damage that occurred.
Yeah, that was over $315,000 just in itself, Your Honor. And then the other damages we asked for that they apparently granted was, the delays and the extra time they had to spend in alternate housing, which is something that would be covered, and
Good.
some miscellaneous things. And and rebuttal, or my rebuttal argument, I said, yeah, don't, they're right. They didn't lose any money on the mobile home, so we're not asked for that. That's basically accounted for the differences right there. And I also told them that as far as the personal property, we applied a depreciation thing of 10%, but whatever you think is fair. And so they came fairly close to that as well. So that was kind of a, just a, one where it was only a few $1,000s we're talking about anyhow. But I think the insurance company is responsible for, since it's damage to the existing home, damage to personal property, and consequentials flowing from the damage to the existing home, that they would be on the hook for the entire amount of the judgment, plus 12% penalty interest, as we briefed it as well. And then judgment interest. And I can remind the court, we still haven't ruled on our claim for attorney's fees on the motion of reconsideration.
I noticed that on my desk as I was loading these up. I thought I still owe an opinion on the reconsideration on attorney's fees.
Yes, which could be, and given all the work on this case, that's going to be substantial, provided if the court does grant us attorney's fees. So I think it's pretty clear that this, all their claims of exclusion don't apply, and all their claims that wasn't an occurrence isn't true. Facts that, pretty much we've briefed it all and indicated why they should be paying the entire judgment.
All right. No, thank you, Mr. Boncher. Let me give Ms. Pinch an opportunity to respond. And I guess I'm going to lead off with that same question I posed to Mr. Boncher. Ms. Pinch, is there a universe here where I and my, of course, judicial wisdom is supposedly infinite as I place this black robe on me, but I know a lot better now, having done the job for 8 years, that it's more limited than that. I split this thing up and say, well, certainly there would be a dollar coverage amount for a casualty loss for, say the possession's damaged and, some portion of the weather damages that occurred on the site, that were casualties. But on the other hand, some of this was not covered because it was contract. Is that within my capacity to do it?
No, because the jury didn't do that.
Okay,
You're bound
all
by
right.
the jury giving a lump sum verdict, and the issue
And
is
that's,
whether or not.
it is what it is. And if I
Yep.
try to do anything else with it, I'm essentially guessing at it.
Yes. You're
And-
putting
and
yourself
some-
in the role of the fact finder when the fact finder has already made its determination, made its ruling, and judgment has been entered.
And as a matter of curiosity, did you request a jury on the deck action?
No.
I don't, yeah, we usually don't, so I'm
So
gonna
that
say
would
no.
be if I find fact questions here, which is, a distinct possibility, then I'm not shifting responsibility. I'm just kicking the can down the road in this case. So
I'm just trying to open the document to confirm Mr. Boncher's statement. It doesn't, we never do, because it's not really an area for a jury to make that determination. It's strictly a question of law.
I would
And
agree.
no, we did not make a jury demand.
And Mr. Boncher, you resisted the temptation to respond with a jury demand in your answer here.
Yes, I did, Your Honor. This is up to you. So
I greatly appreciate the trust placed in me, although it substantially increases my workload and requires me to activate brain cells that I haven't had to draw on in several years. But it supposedly is going to keep me active. Hopefully, as long as you've been able to keep going, Mr. Boncher, that's what I'm shooting for here. So
yeah, well, I'm blessed with incredibly good health, Your Honor. But this is kind of like the end of the line. I mean, we have a trial date, but it would be just a waste of time since it's a bench trial anyhow. And we
Right.
have a,
We may have enough here for me to decide, but well, that's not going to be necessarily before me today. Let me give Ms. Pinch an opportunity before I got off too sidetracked here.
Thank you, Your Honor. I'm going to respond to Mr. Boncher's arguments in sort of reverse order because the simpler ones were later in his argument. With regard to Strubasher or Salomon's financial situation, that has absolutely no bearing on the coverage issues that are before the court.
Agreed. It may be true and absolutely accurate, but got nothing to do with my decision today. It's purely a matter of the contract and the underlying case.
Similarly, with regard to the argument that Frankenmuth provided counsel at the trial, the court is correct that that was under a reservation of rights. Part of that reservation of rights included our ability to seek restitution for cost and attorney fees and expenses if it is found that coverage does not apply. So that again has nothing to do with the issue of whether or not the Salomon brothers have coverage for these claims. Mr. Boncher argued that they're claiming damages because of exposure to the elements and not a workmanship claim. And that's how he's trying to get around the your work exclusion. And it simply doesn't work because you don't have exposure to the elements if you didn't have the underlying workmanship issues. And those are the issues that were focused on in trial. There were extensive photographs shown with testimony about, yes, this depicts how these rafters and these beams don't line up. That's workmanship. This depicts how there's this board that just ends in the middle of nowhere and is unsupported. That's workmanship. They didn't tarp properly. That is workmanship. That's all part of what they were supposed to have been doing in their work. You don't get the exposure to the elements if you didn't have poor workmanship to begin with. And to argue that this isn't anything about workmanship, it's just about rain getting in, is skipping the preliminary step, the catalyst for the exposure to the elements. Once the catalyst is found and there's no coverage for that catalyst, then there's no coverage for what happens as a result of it. Mr. Boncher even stated that in terms of the your work explanation, the your work ends, and he stated specifically, when you abandon the property and never come back. And we agree, that's exactly what I told the court. The project began when the first shovel or first nail or first board was put in place and ended when, through whatever means, Salomon left and never came back. We agree on that. That doesn't affect coverage, and it doesn't negate the work exclusion because anything done in between that time period falls within the work exclusion.
And I think you're also saying that even after that, if what we've got there is really faulty workmanship, i.e. a totally defective tarping and protection of the site, and he never comes back, and there's a dispute about it, and likely negligent conduct involved on his part because he should be coming back and checking up on his workmanship and making sure it's holding up for months and months with this long delay. Nonetheless, it's still workmanship.
Yes.
Okay. Yeah, I think I understand where you're coming from.
All right. And Mr. Boncher also argued with regard to the issue of an accident, stating that the exposure to the elements was the accident. An accident under the insurance policy between Frankenmuth and Salomon refers to the conduct of the insured. What did they do that was an accident as opposed to an intentional tort? They didn't make the rain and snow come in. It was their workmanship that did, and workmanship was not accidental. The fact that the snow and the rain came in as a consequence of their intentional acts does not turn the intentional act into an accident. So you can't look at the outcome, you look at the actions, because that is what is or is not granted coverage, the actions of the insured.
If I can back you up or pause you just a minute on both the workmanship and that the other exclusion claimed here, both reference the particular part of the real property. And one of the issues I run up against here is that says to me, Judge, you ought to look at for example, a window or a roof truss and say, the workmanship on there was improper and thus it falls under the exclusion. The issue I have with tarping and kind of what I'm going to lump into is, site protection from the elements is it seems to be broader than that. It seems to go beyond a particular part. It in fact, implicates the whole project. How do I clear that, in terms of ambiguity?
Sure, Your Honor. If this was an instance where you hired someone to hang a new door in one room of your house, and the
Sure.
door's on one wall and on the opposite side there's a window. And in hanging that door, they somehow managed to break the window. That's separate. Those are not the same work areas. Here we have a project, and because nothing was ever put in a written contract, and the oral agreement was always changing, arguably the project encompassed the entire house, not just one specific area. So to that
Well,
extent,
interestingly, when they originally contemplated it, and even the briefs kind of touch upon this, they thought, well, we can have this remodel done to certain portions of the house, but certain are going to remain untouched, and thus we can store stuff. And that turned out to be part of the, kind of mutually incorrect assumption made at the outset here was that, this was going to be limited to discrete areas. And of course, at the end of the day, the damage got so extensive that it did necessitate a tear down and rebuild. I don't think anyone questioned that. So, but yeah, interestingly, the facts in the trial, I guess, came out that, what Strubacher originally sought to do and what the Hansons thought he was going to do, because they stored their stuff in the other parts of the house, was limited, to a discrete project. It wasn't as broad. Does that change my
no, because
analysis?
the testimony at the trial was also by both parties agreeing that there were multiple changes to the scope of the project throughout the course of it. It went beyond whatever that first undocumented agreement was.
Yeah,
There was
really,
no
any
evidence before the
contract
court.
is, yeah, there's
There
no
was no evidence
agreement.
before the court or before the jury as to what the scope of the original project was supposed to be and what it evolved into based on the unwritten agreement and the unwritten change requests that everyone acknowledged it happened. With regard to the unjust enrichment claim, Mr. Buncher spent a significant amount of time on that. And the issue I have with that is that the jury instructions to the jury specifically said, if you find breach of contract, do not address unjust enrichment and promissory estoppel. The fact that the jury even acknowledged that and checked it was error on its part. They never should have addressed that issue had they followed your instructions. Clearly, in making those instructions, the court recognized that there was a relationship between the breach of contract claim and the unjust enrichment promissory estoppel claim, that it wasn't a separate thing of its own. But if you find A, you can't find B. The fact that the jury ignored that negates your instructions. Specifically with regard to this issue about negligence, there is no doubt and there is no question that the complaint as pled did not allege negligence as a cause of action. There was never an amended complaint filed or submitted or proposed even adding a count of negligence. To now state that you can amend to conform to the evidence, that is true, but you can't amend a year later after judgment has already been entered when the evidence of arguments regarding negligence were never raised. They were never presented to the jury. There were no jury instructions presented to the jury on negligence. There was no blank space for negligence on the verdict form.
Can negligence be a component of unjust? I mean, unjust enrichment is a tort action, correct?
Actually, I was trying to find that out.
Quasi-contract?
I was looking on Westlaw while Mr. Boncher was arguing, and there is case law that says it can be quasi-contractual, or it can be a part of negligence. Again, we don't know how that was pled, and the fact that you, Your Honor, instructed the jury, if you find there's a breach of contract, do not find unjust enrichment, indicates that you yourself, at least at that point, perceived them to be related.
Right. Well, in that if they did find the entire amount under a breach of contract or a fraud misrepresentation theory, I guess just in the most simplistic terms, and they awarded the entire amount there, then it rendered that at very least moot. by that point on the verdict form, they'd already awarded, unless they thought there was some discrete dollar amount. In my recollection of putting it on there was, well, there was very distinct testimony that these folks paid a certain amount to Mr. Strubacher, and, not only got essentially, defective work and in return for that, but, damage that ultimately cost them more to fix than, they paid to him in the first place. So, that no question they got a short end of the stick with Mr. Strubacher. And I guess the question is, in a reading most generous to both Strubacher or to Solomon Strubacher and the Hansons, is there coverage there? Can coverage be invoked under negligence? And I'm not certain as we sit here today if that fits.
If I could add also, Your Honor, unjust enrichment wasn't pled as a separate count. It was pled in conjunction with promissory estoppel, which is undoubtedly a quasi-contractual theory and is not a tort. Plaintiff did not plead negligence in any way, shape, or form. He didn't ask for it on the verdict form. He didn't argue it to the jury. There were no proofs put on with regard to any of the elements of negligence. And defendants, the underlying defendant, Solomon, never had an opportunity to defend any negligence claim simply because they weren't there. To now, a year later, say, well, he could have pled negligence, but he didn't. Mr. Boncher could have pled it in the initial complaint. He could have filed an amended complaint. He could have made an oral motion to amend the pleadings to conform to the evidence at the time of trial. He didn't do any of that. Instead, now a year later, in retrospect, perhaps realizing that all of his claims have no coverage, he's trying to wiggle his way into a negligence claim that simply does not exist and did not exist at the time of the trial. If I can respond briefly to his arguments on his own motion, he's arguing that an occurrence was shown by the findings of the jury and proofs based on the finding of damage to the home and property. The fact that there was damage is not indicative or dispositive of there being an occurrence. And that damage could have been intentional. It could have been unintentional. It could have been an accident. It could have been something else. We don't know.
Been an act of God, maybe. Right.
And arguably rain is an act of God, but the tarping, the work, allowed that act of God to get into the house. Solomon did not accidentally fail to protect the existing home and property. It didn't accidentally breach its contract or warranty, and it didn't accidentally make any fraudulent misrepresentations. As I've now beaten that horse to death, there's simply no occurrence here. The jury determination of damage to the home and the fact that they awarded a verdict does not mean that there was an occurrence found. They weren't asked that question. They weren't asked, was there an occurrence? Was there an accident? They were asked, what is the value of what happened? And they answered that. Under Mr. Boncher's reasoning, the term occurrence becomes superfluous in any liability claim because any bodily injury or property damage would be deemed an occurrence simply because it happened under his argument. And that you can't negate the policy language. That would completely make it a nugatory and void provision within the contract. You have to interpret the contract as written. The contract as written defines an occurrence as an accident, and there's no finding or no evidence of anything that was accidental here. With regard to the argument that the verdict reflects the cost of rebuilding the home and that Solomon in the trial or briefing after trial admitted what the damages should have been. Again, the nature and amount of the verdict has nothing to do with coverage issues. It has nothing to do with whether or not Frankenmuth is responsible for that. The jury found there was damage and the jury found that that damage had a monetary value. It didn't make any admission, Solomon didn't make any admission as to whether or not Frankenmuth was obligated to provide coverage. It can't make that admission. It was not its admission to make. And we certainly never made that admission.
You made the opposite because you reserved your rights, I suppose.
Exactly. And the amount of damages, whether the Hansons were awarded $10 or $10 million, has nothing to do with the coverage issue. That isn't, the coverage issue is determined by the facts underlying the claim, not by the amount of the damages. They're unrelated entirely.
And just to back up a moment there, because I think that does play into Mr. Boncher's argument here. If I look at the facts underlying the claim, well, it's easy to find and say, well, certainly as poorly and shoddily as the work was done, it was intended to protect the house when it was completed, the tarping specifically, and that, if it was then, ergo, it was done negligently because the weather did intrude, and again, time expired there too. That tarping that might have worked overnight was not good enough to, work for these long gaps in the work being accomplished. And thus, I think there is negligent conduct there that can be found. But you're saying, even if I find that, I can't look beyond the pleadings in the complaint to find coverage there.
Correct, because the issue of negligence was never presented to the jury in any way, shape, or form. Not legally, not factually, not on the verdict form, not by an oral amendment to the pleadings, nothing. It was never before them. So the court cannot now say, well, they really were finding negligence and this is what they were really thinking. That's beyond your authority, Your Honor. You cannot presuppose what the jurors were thinking when they rendered their verdict and their opinions.
Sure, and I guess what you're also saying is it would be beyond me to, even though I instruct juries, on direct evidence and indirect evidence, that I can't say, well, they said they did tarping to protect from the elements, and there was all this damage, as you pointed out. That doesn't seem to be, disputed at this juncture. Therefore, there was negligent tarping, and thus a basis for coverage.
Correct.
I mean, you can't infer that from the facts that they did find.
You cannot infer anything as to what the jury thought or may have been thinking when they rendered this very confusing verdict that found for all 4 counts and then awarded a lump sum, all of which could have been avoided had we been allowed to participate in the jury verdict and the jury instructions formation. The last thing I want to address is that plaintiff raised in his motion the issue of collateral estoppel. And collateral estoppel does not apply in this situation. Obviously, the court's familiar. Collateral estoppel requires the same parties or privities and the same issues. These are not
Yeah,
the same.
I agree with your argument there, and that the issues are different. Clearly, right, and for that matter, right, Frankenmuth obviously wasn't a party. I did deny that motion partly because I thought it would be confusing and difficult for the jury to, and my recollection of the motion to intervene was a limited one where Frankenmuth didn't want to appear as a party in the case and assert any direct interest, but rather wanted to intervene for a limited purpose, that being to participate in the creation of jury instructions in the verdict form. Is that accurate?
Yes, it is, Your Honor.
Yeah, that's what I thought, and I did deny that before trial. So. Okay, well.
Okay, then I will not
Yep.
address anything more on collateral estoppel based on what the court just stated. I would just ask that, having looked at these motions kind of concurrently, I would ask that the court grant Frankenmuth's motion for summary disposition, awarding us declaratory judgment, and in doing so, awarding us restitution against our insured Solomon Brothers and Straussbacher. And I would ask that the court deny Hanson's second motion for summary disposition, for essentially the same reasons.
All right. Well, what I am going to do.
Your Honor, can I just?
Yeah, go ahead, Mr. Boncher. I don't want to deprive you of time here, and all you're cutting into is my lunch hour. That's okay. I've stored up enough I can miss a meal.
Well, Your Honor, I think this is all be answered, this idea about we didn't plead negligence, by looking specifically at MCR 2.118C, when it says amendments to conform to the evidence. When issues not raised by the pleadings are tried by express or implied consent of the parties, which I think that was clearly the case here, because all we talked about was the damages result from the failure to properly secure the property, comma, quote, they are treated as if they had been raised by the pleadings. That answers the question of whether we talked about negligence at all. In that case, comma, amendment of the pleadings to conform to the evidence and to raise those issues may be made on motion of a party at any time, even after judgment. At any time, even after judgment.
So even today, you think you could file a motion to amend that original complaint to make an allegation of negligence?
Exactly right. And C2 says if the evidence is objected to at trial on the ground that is not within the issues raised by the pleadings, amendment to conform to that proof shall not be allowed unless the party seeking to amend satisfies the court that the amendment and admission of the evidence would not prejudice the objecting party. Well, they never made any objection at all throughout the entire trial. They didn't make any objections to the jury verdict form. They didn't make any objections to any of the instructions. They waived all those arguments.
Well, arguably because I denied them the opportunity to intervene when they might have made some objections there. So.
But Strobisher never objected during the trial that there was no confirmation, that wasn't raised by the pleadings. And that's what we look at. So that gives us the opportunity at any time to amend in the underlying case, which would make it very clear that there is insurance coverage. Likewise, MCR 2.116 I5 says that in response to the summary disposition motion, if the grounds asserted are based on subrule C8, 9, or 10, which is what basically covers all the claims made by Frankenmuth, the court shall give the parties an opportunity to amend their pleadings as provided by MCR 2.118 unless the evidence then before the court shows that amendment would not be justified. So to resolve all this stuff, you allow us to amend and we can file a separate motion in the underlying case because we can do it at any time to add negligence. I am sure Mr. Strobisher is not going to object to that because he doesn't want to have to pay this judgment himself. Then we have that amendment. And then in this case, we then say we amend the matter in this case, the Frankenmuth case, to say that this negligence was something that, in fact, they probably agreed to negligence. Strobisher would, because that's his own best interest. And then we bring in this case and say, well, Judge, you have allowed us to amend in the underlying case, and it's really negligence is clearly covered. Make him pay the whole thing.
All right. Well, certainly any amendment at this stage, this very late stage, would have to be by motion. And certainly, if I can allow amendment, I can probably allow intervention, and certainly it seems like the Frankenmuth's interests are more directly involved. So it'd be highly likely that I would allow intervention at this late stage by Frankenmuth to resist amendment if they felt that was legally appropriate. Is that a potential response to the motions before the court from your perspective, Ms. Pinch?
Your Honor, with regard to this issue about a motion to amend, first, Mr. Boncher would have to file a motion to reopen the record in the underlying matter, then have to file a motion for leave to amend the pleadings. Then, and presenting a new issue to the court that has never been argued before a jury, we would have to redo the entire trial.
You have to redo the entire trial, you think?
Correct. The jury was never presented with any issues regarding negligence. It did not make any findings regarding negligence. It didn't make any award regarding negligence. And the court doesn't have the capacity to do that. That's a jury issue that the jury did not address. This motion would not apply in this case. And as far as I recall from sitting through the trial, at no point was there any express or implied consent between counsel for Solomon Brothers to amend the pleadings. So that issue, that part of the argument is void as well.
Your Honor, it doesn't have to.
Mr. Boncher, please allow me to finish.
Yeah, let me finish. I'll give you another chance, Mr. Boncher.
You cannot go back in time, recreate pleadings for the case you now wish you had pled a year earlier, and expect the court to now interpret what the jury might have done had it had that claim before it and the arguments and all those other things. You can't do that. That's beyond the power of the court. Those will all become questions of fact for the jury that the jury never addressed. The only option would be to have a new trial, at least on the issue of negligence.
All right, Mr. Boncher, would all that be necessary?
No, because that makes it very clear when issues not raised by the pleadings are tried by express or implied consent of the parties. It doesn't say that you have to bring a motion during the course of the trial. This is to conform to the evidence even after judgment, according to the court rule. And we move to amend, and I'm sure Mr. Strobisher's counsel and representing his best interest would agree to that amendment. And then the jury decision was based upon the express, what the facts showed. And the facts showed that he failed to, that Strobisher failed to properly secure the property, and that caused the damages. And that's really it. We don't have to have a separate trial because, and they never asked to intervene as a party plaintiff or a party defendant. If they would have, it would have made my case a heck of a lot easier when we had an insurance company defendant in front of the jury, but they chose not to do that. They just wanted some input on the jury verdict
On
form.
the verdict form ultimately, right, which might have solved this problem, but also might have created additional confusion that
Yeah.
also have to deal with. So all right, yeah, hindsight's always 2020. Well, here's I guess and Mr. Boncher, clarify for me, the underlying case, is it on appeal right now?
No, we haven't gotten final judgment yet, Your Honor.
I haven't, because I'm still pending on.
So that's still pending. That's another thing. The case is still pending.
Well, I certainly can get my reconsideration order done and out the door to
Yeah, we can amend even before the final
We'll do
judgment
that.
because it's at any time, even after judgment.
yeah, so even theory, if it were up on appeal or the judgment was still on appeal, you could still amend.
Yeah.
However, any amendment would have to be by motion, obviously.
Sure, and I can file that tomorrow. And the
So
underlying.
that's what I'll do here is let's have a motion to amend the pleadings in the underlying case.
I'm sorry,
And
Your
I
Honor,
viewed that. Yeah, go ahead, Ms. Finch.
it's my understanding that judgment was entered in November of last year. I'm trying to find it. In which case the case is closed and there would have to be a motion to reopen first.
Well, I'll leave that to Mr. Boncher and you to figure out. My recollection, I know there is still that motion for reconsideration pending because I came across it when I was pulling together the pleadings that I had to review for today's argument. So I do know that I do still owe one decision there, but I am uncertain, how if that delayed the entry of judgment or not. So what I will do is I'll allow, what I am going to do, I guess, is I will take this one under advisement. Part of that basis for taking it under advisement will be so that there can be a motion to amend filed in the underlying case and render a decision on whether or not the complaint can be amended at this late date to conform to the evidence because Mr. Boncher alleges the evidence, and certainly the court will acknowledge here, though without having reviewed the transcript, I don't have any specific citations that some of the testimony during the trial can certainly be construed as negligent conduct. However, I do think the proper way to do that procedurally is through amendment of that original complaint.
And if necessary, Your Honor, I'll reopen. I just had a case that was reopened up in Newaygo County. So, I mean, that's kind of routine and no problem for me to bring a motion in that regard.
Very well. Well, let's proceed in that manner for the time being, with this matter being taken under advisement, pending the resolution of that, because I view that as a potential, dispositive issue on resolution of these issues, and get that decided, and then after the decision's rendered on that, that may clarify and in fact, what I'm going to do just to clear up on the timeline here so I don't get crunched by that rule of matters taken under advisement, I will deny both of the parties' motions today without prejudice so that they can be re-urged following the resolution of the amendment in the underlying case. So I will do those.
And Your Honor, I should be able to get that motion filed within a week. Without any problem.
Very
And
good,
if it's two motions that.
Yeah, if it's a couple, let's do it procedurally correctly because, of course, it is important to create that record. Ms. Pinch?
Your Honor, will you allow Frankenmuth to intervene for the limited purpose of responding to this motion, as we clearly have an interest in the matter?
Yes, I think that would only be appropriate in that case, is that Frankenmuth, I would presume that intervention would be permitted. Like I say, if amendment's permissible this late, then intervention as well, because after all, Frankenmuth's interest is the only interest that's represented by counsel today. Strubacher and Solomon are not. So.
All right, we'll file that limited appearance when we file our response to the motion, then, if that's all right with the court.
That would be acceptable as far as I'm concerned.
All right.
Very good. Thank you, both parties. It was the briefings were very thorough and focused me on the issues that were appropriate. And I think, though, about as satisfying as the proverbial tie can be in any litigation, I think we're at least moving the case, moving the ball down the field, as they say.
Okay, thank you, Your Honor. Have a nice
Thank you, Your
week.
Honor.
Thank you.
So long, everybody.